Thank you for staying tuned. The Federal High Court, Abuja Division, has adjourned to 20th May 2024 to rule on the bail application of the leader of the indigenous people of Biafra, Nnamdi, Kanus. At the adjourned date, the court will also rule on the defendant's prayer for his removal from the custody of the Department of State Services to house arrest. Nnamdi of our Judiciary Desk reports.
The leader of the indigenous people of Biafra, Nnamdi Kanus, who is standing trial on allegation bordering on terrorism, brought two applications before the Federal High Court sitting in Abuja. The first application has to do with the prayer for the restoration of the defendant's revoked bail, while the second application was on the request for his removal from the custody of the Department of State Services to house arrest. Nnamdi Kanus, who has been in detention since 2021, in a motion argued by his counsel, requested the court to restore the bail granted him in 2017 by the trial judge, Justice Binta Nyako. The defense team told the court that contrary to the alleged claim of the federal government, he did not jump bail or breach any of the conditions of the bail, but had to escape out of the country when the military allegedly invaded his house. Nnamdi Kanus alleged the federal government of misleading the court to get his bail revoked in his absence. The defendant also prayed the court to set aside the arrest warrant issued against him by the court while he was out of the country. In addition, the defendant equally prayed the court that his lawyers must be allowed unhindered access to him to enable him prepare for his defense in the terrorism counts against him, adding that until those conditions are met by the federal government in line with Section 36 of the 1999 Constitution as amended, he will not submit himself for trial. However, the federal government's legal team led by Awomolo SAN vehemently opposed granting of all the requests made by Kanus' legal team. Awomolo SAN told the court that in a criminal matter, no defendant has the right to dictate to the court how his prosecution would be conducted. The prosecution counsel also told the court that Kanus was once admitted to bail but breached the bail by escaping out of the country under false claims. Omolo SAN argued that the fresh request for bail by Kanus was a gross abuse of court process, having been rejected earlier by the same court, adding that the only option available to the defendant is to go to the Court of Appeal to challenge the rejection, since the High Court cannot overrule itself. On the request for removal from DSS custody, Awomolo SAN said that the only safe and secured environment for Kanus remains the DSS custody in the interest of safety of his life. He urged the court to dismiss the allegation of hindered access to lawyers by Kanus, adding that in his application and the supporting affidavit, Kanus failed to name any DSS operative hindering lawyers from accessing him. The matter has been adjourned to 20th May 2024 for ruling. In Abuja, Nnamdi, NTA News.